Good afternoon, everybody. My name's Jake Thompson. I'm an attorney at Otterman and Allen, PC. We're a firm in Barry, Vermont, and we mostly specialize in estate planning and probate administration matters. We've got everybody in here. I'm ready to start. And feel free, anybody, to throw a hand up. Any questions as we go through here. I've just got a kind of general outline here of some of these estate planning devices that I want to talk about, but by all means, if anybody has any specific questions, you can ask those. And the first item, the first document that we're going to talk about is the last will and testament. So this is typically the most common. This is what anybody thinks about when they're thinking about estate planning. There's several requirements to a will. Your will needs to be in writing, and you need to sign it. And you need to sign that in the presence of two witnesses, and they need to sign it as witnesses. Those are kind of the technical requirements of your will. And there are some other elements to a will. You need to have capacity in order to make a will. And in order to have capacity, you have to know your natural bounty, which means if you have any children, or if you don't have any children, you need to know your family or your friends. You need to know what your situation is. You also need to know what you have for property. So that includes real estate if you've got a house, or that includes bank accounts if that's primarily what you have, or it could be personal property of any value. And the final step to proving capacity is being able to put those two pieces together and establish a plan. And so when we meet with clients, those three elements are what we're looking to establish through our meeting. Figure out if the person knows the objects of their bounty, whether they know what they have for property, and whether they can make a plan with our assistance, of course. And so, specifically, what the last will does is it controls the disposition of your property on your death. Now, it controls the disposition of your property that's solely in your name. That's an important piece to factor in, especially nowadays when there's a whole lot of ways and methods of establishing what we call non-probate transfers. So that's outside of court. Ways to do that. Could be a beneficiary designation on an account. It could be a deed, like the enhanced life estate deed that we're going to talk about. The will also lays out who you want to act as executor to carry out your wishes, to make sure that the terms of that will are carried out. And the final point that I just want to make is that it's very important that you have the original will. When you go to court, a copy does not get you anywhere. You need to have the original. And we typically refer to that as blue ink original because we typically use blue ink. And as I mentioned, non-probate transfers, these are becoming more and more important. The modern goal of estate planning largely is avoidance of probate court. And so what I'm talking about when I mention probate court, it's when somebody's passed and you have a will, you bring that will to court, and you have to process the estate. You have to administer the estate. And that's becoming more and more of an arduous process as time goes on. And it's not because it's a terribly complicated process, it's because it's a timely process. Courts are getting more and more backed up, and it takes them longer to carry out the steps of estate administration. And so that's why non-probate transfers are so important. So the typical ones that you run into, beneficiary designations. If you've got any sort of a retirement account, they probably made you set it up with a beneficiary. Typically that's your spouse first. In the second case, typically it'd be your children, whoever you want in that spot, but they're legally required to make you put your spouse on there if you're married. Another element or another example are these enhanced life estate deeds that we're going to talk about a little in greater detail later on. And it also could be a trust. That's another method of probate avoidance. Trusts are much more expensive than these other non-probate transfer methods, and generally aren't recommended in every case, especially if these other avenues are available. And just as a final comment here, non-probate transfers, any of these, what you're kind of trying to do is make that estate administration easier by taking steps now. And there could be costs to some of those steps, like a trust or a deed. You've got to pay to have those prepared, or it's certainly some effort that needs to be put in, but you're looking to save time and money later on. And so specifically, one of those non-probate transfer methods that I mentioned is the enhanced life estate deed. And this is kind of famous here in Vermont. These are very typically done. What these are a deed to your children or to any other beneficiaries that you would like to receive your property on your death. And what these look like is just a straight up deed. If you read the first paragraph, it looks like it's going from you, the owner of the property, to these beneficiaries. Now, in the legal description, we include a paragraph that discusses enhanced life estate rights. And as grantor of the deed, you reserve those enhanced life estate rights. And those rights include the right to live there, the right to sell the property, the right to lease the property, the right to mortgage the property. Essentially, you're still the owner of the property, yet when you die, it passes automatically to whoever you named in that deed. Another important element to this is there's no transfer tax when it's to your children. If it's somebody besides your children, there is a transfer tax on that deed, but there's also a transfer tax when that property gets transferred through the estate administration process. So,
what about to your spouse?
There is no transfer tax in transfers to your spouse.
What if it's to a church?
To a church, there actually is a transfer tax. This is not a very intuitive thing, and we've run into this several times. Folks kind of just assume that to a charitable organization that there's not going to be a transfer tax. But in this case, the state of Vermont does still require a transfer tax. Now, when you do these enhanced life estate deeds, that tax isn't based on the full value of the property. It's based on the value of what we call the remainder, what you're transferring. You're transferring to your children or the beneficiary, whoever they may be, what's called the remainder. Once your rights are done, they receive the remainder. So that does save you on transfer tax. There's less transfer tax than there would be if just on your death, the property went through, say, the probate court to whoever you want that beneficiary to be. Of course, again, if it's your children, there's not going to ever be transfer tax. And as I said before, this is automatic, this transfer. You don't need to do anything further beyond the deed that you've already recorded. The only thing you might need to do is you might need to record a death certificate in the land records if your children or if your beneficiaries wanted to sell the property. Another very important element of these deeds is that these are a method of Medicaid preservation or protection. That's becoming more and more important for a lot of people.
What does that mean? Sorry.
Yep. I think I'm going to kind of go into it now.
Okay.
So, just a little bit here, we're going to kind of brush on some of the basics of Medicaid. So what I'm talking about when I talk about Medicaid is this is a program to cover your long-term care services if you reach a point in your life where you need those services and you don't have insurance or other financial ways to cover those expenses. So there's pretty stringent limits to this program. You can only, if you're a typical recipient, you can only have $2,000 in liquid assets. That's all you can have in the bank account in order to qualify for the Medicaid program. Now, there are exempt assets. These are assets that you're allowed to own, and Medicaid does not consider them in factoring your eligibility. One of those exempt assets is your home place. If you own your home place, Medicaid says that you're allowed to retain that home place and you don't have to sell it. Now, it has to be your home place when you go into wherever you are for a facility or assisted living facility. You can't have been in a separate apartment. It needs to have been your home place. But you're allowed to continue to own that. And what this deed essentially does is you're still owning the property because you're on that deed still. And when you die, it passes automatically. And Medicaid doesn't get a chance to make a claim against it. So what that last note is Medicaid recovery. This is how Medicaid looks to get paid back after they've paid expenses for you. I put up there average cost of like $10,000 a month can be nowadays, if not more. So those costs add up fairly quickly. And when somebody passes away and your estate is opened in the probate court, Medicaid gets a notification at their Medicaid recovery office that your estate has been opened. And once they get that notification, they make a claim against your estate to recover those funds that they've paid for you. Yes?
Is that true in a small estate?
Correct. They should get, I don't know that I've specifically run into yet a Medicaid claim against a small estate, but I would think that the same system would give them.
Would the administrator of the estate have to disclose that there was a Medicaid recipient to the court, or how would they know? How would the court know?
Well, the court doesn't specifically know, but when an estate opens, I believe that it's a general process that Medicaid gets a notification whenever any estate is opened. And then they check their records to see if they have any claim to be made at that point.
Okay.
But essentially, this is a way to avoid that because the property doesn't go through the estate process in the court. It passes automatically. And Medicaid doesn't, they specifically allow this at this point. They understand that these deeds are out there. They haven't changed the laws or regulations to get rid of them. There are some states where you're not allowed to do this. Vermont's kind of a little unique in that we're able to do this. So as long as the laws and regulations don't change. But even not considering that, the deed is still a large convenience being able to pass that automatically, even when Medicaid isn't a factor. The final document I just wanted to touch on are powers of attorney. So what I'm talking about are financial powers of attorney. We talked about advanced directives with Cynthia here in the earlier session. These are powers of attorney for your financial matters. Now, this is somebody that you're appointing as agent to act on your behalf in connection with your bank accounts or with your real estate or with any sort of taxes you might owe. These are pretty broad and encompassing. And there's two kinds of powers of attorney. The first are durable. Now, when you sign a durable power of attorney, it's effective as soon as you sign it, and the agent's able to act as soon as they accept appointment. But the second kind are springing powers of attorney. So what those are is they only become effective when you're incapacitated. So you're not able to make any decisions for yourself, or you've reached a medical situation where the doctors consider you to be incapacitated. We generally recommend durable powers of attorney when we're doing estate planning because some people want assistance from their agent when they're not incapacitated yet. As long as, if you still have your wits about you, you might not be incapacitated, but you might still want somebody to help you with these things. And there's kind of another differentiation here between a general power of attorney and a limited power of attorney. General, again, is very broad to say, my agent can do anything I could do if I was president. Whereas limited says, my agent can only do this for me. And these documents are getting more and more detailed because every institution wants to see a specific provision for them. So, in the old days, you used to list just a paragraph for banks. But credit unions didn't like that. You needed to change the language to include them. So these can be fairly long and detailed. And final piece I wanted to touch on in powers of attorney is that in a power of attorney, you can also nominate who you would like as a guardian. Now, powers of attorney are an appointment of an agent. That's somebody to act for you. You can always tell your agent what you want them to do. And your agent has to listen to you. But if you reach a situation down the line where you're not making good decisions, and say your agent or somebody else sees that this is happening and wants to do something about it, they might proceed with a guardianship. Now, a guardianship is a level above agency. A guardian can tell you what to do, but they're still a fiduciary, and to get to guardianship, you have to go through the probate court process. And but what you can do in a power of attorney is say, if I ever need a guardian for any reason, I want my agent to be my guardian. So that's another piece of powers of attorney. And I just wanted to touch on advanced directives. There was a whole session on these, but these are just another element of the estate plan overall. It's your agent in context of medical matters. And then this is kind of just the probate map, so to speak. I wanted to lay out, we kind of do a bit of a sketch sometimes for folks. So we kind of start up at the top. That's where the decedent kind of is. You've got assets, you've got your home place, you've got accounts. And then you've got the will. And now that will gets taken to the probate court. And that's the instructions for the probate court on what you want to happen to your property. But as I said, when you open up an estate in probate court, Medicaid recovery gets a notification. And if they've got any claim to make, they're going to file it with the court. And finally, below the probate court are your ultimate beneficiaries after the estate administration process is through. But those beneficiaries only receive something if there's something left for them to receive. And a creditor's claim like Medicaid recovery could very easily wipe out whatever's in the estate. So we've got over on this other side, the enhanced life estate deed. Kind of short circuits the probate court process, transfers your home place that way, and goes directly to the beneficiaries without going to the court. And as far as the probate process itself, you've got to send in a petition, you've got to send in a will if there's one out there, and then the court has to either allow the will or not, and appoint either an executor or an administrator if there is no will. And the executor's job is to collect and preserve the assets, wherever and whatever they may be. And they've also got to figure out if there's any creditors out there. Is there anybody that is owed money here? A lot of times you run a notice to creditors in the newspaper. That shortens the period of time for creditors to file, and it officially gets the notice out there. And then you need to pay any administration expenses, taxes, and then the creditors. And then finally, if there's anything left, that's what gets distributed. And I think that's all that I had specifically structured. I don't know if any of you have any questions about any of these documents or the estate planning process.
I do. I have a question more about the durable power of attorney and this. I had never heard of the word springing power of attorney. Is that a new term, or is that like?
Well,
I just hadn't heard of it.
It's not often used. I'll say that durable is much more common. Spring is a way to and there's other more technical terms, but the springing is kind of the nickname for it, so to speak. It's the springing power of attorney versus the durable, which is just automatically in effect. It's called springing because it springs into existence when you become incapacitated.
I thought that's what a durable power of attorney was, and then just a straight power of attorney was.
Nope, durable is effective as soon as it's durable because it's effective. Generally.
So would they specify in the durable power of attorney that you only want their duties to kick in under certain circumstances, like if they're incapacitated, or?
Well, no, I mean that's the
just
difference.
is.
Yeah,
Okay.
that's the difference between that.
Well, my husband was the executor for his brother's estate who passed in 2019, and we just went through this whole small estate process,
Mm-hmm.
and the judge signed off in January of this year. It was hard. He has small estate.
And
It
as
seemed like so many details, and we didn't even know that we had to open it, an estate or whatever until like almost 2 months after the death. And I just happened to come upon the information on the internet, and I went, oh my gosh, are we going to be doing something wrong? Because he was the executor, he was this, whatever. So I, covered his back, so to speak, and then we got, all these things in order and whatnot. But identifying even the personal property was horrible to me. It was identify every little thing because it all had to be put up for sale, and we had like 6 different sales to raise just enough to pay, just the things at the top of the list. And I mean, honestly, we had like 8 creditors out of 30 that filed an official claim.
correct.
But they didn't get anything.
Yeah.
There was nothing. The funeral home got what they needed, the attorney got what they needed, the administration got $21, and nobody else got anything. So,
Right.
it doesn't always work out for the beneficiary.
No,
really.
It doesn't, and a lot of it's important to note that just because somebody has a will, it doesn't mean that means you're automatically in the clear.
Even those beneficiaries' items cannot be distributed
Right.
until
the creditors.
because they're part of the assets. So that doesn't mean they automatically get whatever and can come in and get it.
Right.
And the thing about the creditors, if you don't put that notice in the paper to close off a 4-month window of them being able to file against the estate, and you don't do that notice, they have up to a year or even longer after the estate is even closed. These creditors can come out of the woodwork and say, oh, I just found out that this person passed, and we're filing a claim against the estate. So we put that notice in the paper, and we sent it to every creditor, all 30 of them, and said, you have a 4-month window. Somebody filed after the 4-month window, like 10 months later, and
it's disallowed.
And it was disallowed.
Yep. So that's why, again, non-probate transfers if you can. Setting it up so it passes outside of probate is better. And certainly she's talking about the small estate procedures,
Yeah, the
and,
small
and the,
estate is up
and
to
a full
$10,000.
estate procedure is much more in depth than even the small estate procedure.
Thank
So
goodness.
what are you to do if you're Vermont state, say your family's not near you, doesn't know Vermont laws? And who is that person that's gonna be the executor? I can understand being an attorney, I can understand to hire you, and you know more than I know, lots more. But who takes care of the personal part of my family and my home?
So, are you talking about with a will? Or are you
With a
talking,
will.
so,
The
you're-
executor.
right, it's gonna be,
I'm just saying, where do you find an executor when you don't have anybody to do that?
well, so, you're allowed to put somebody from out of state in as your executor.
I realize that, but I'm saying that neither one of those things financially is gonna work. This is more than they could do a year away from, they just couldn't. I just wonder if anybody had any indication. There's, how do I get an executor?
Well, I guess that now attorneys technically can serve as executors if you ask them to, if you want them to. We do serve as fiduciaries quite often at our office. It could be somebody else here in Vermont, as long as you trust them and
That's
they
it.
know what's going on. It's like all of these documents. It comes down to trust. Who you want to put on there is somebody you need to trust and have faith in that they're going to carry out your wishes, and that they're going to be able to do that. And now it doesn't necessarily mean that they're going to be able to do it themselves, but maybe there's somebody who knows how to get a hold of somebody that can help them with it.
A trusted friend, or doesn't necessarily mean it would be family, but someone who knows your family, or, yeah, I mean, it's good, it's, just because they're family doesn't automatically mean that you would
No.
trust them enough to be executor or executors, or wanna put that on them.
It's just
Right,
hard.
it's a big undertaking.
Yeah.
That
I was
is.
around when she was doing that, and I thought, oh my gosh.
Yeah, that's actually what I do for people, I help them set up, I get people
You're
to
hired.
you or whoever. It's really, it is. So how do you recommend to people how they would choose an executor or an executrix?
Well, I mean, other than this conversation as to the trusting, I mean, it's not 90% of the time it's one of the beneficiaries because it only makes the most sense. If you're going to be a beneficiary, you've got a vested interest in making sure that the estate gets administered
Right.
and property gets distributed, and so it doesn't matter whether your beneficiaries are your children or somebody else. I mean, if it's somebody else, you might want to put them down. Or again, if it's somebody that you trust that knows the ins and outs and knows about your property enough, and you trust them, they'd be the one that you put down there. Any other questions about any parts of this process?
How much, if I were to tell one of my clients to go see your business, for instance, if, like I have a client that is in the middle of doing some of this stuff, and he's got all of he's figured out everything, where he wants what to go to whom, and so now he's like, well, how much is this gonna cost me to go? Is there like if it's a fairly simple will and durable power of attorney or springing power of attorney, is there like a ballpark, like under 1,000?
So
or?
I would say we charge by the hour for our services. So my rate is $165 an hour. So if you're talking about a simple will and a simple power of attorney, I'm probably around $300 to $400 for a will and a power of attorney.
So if he comes to you knowing what he wants basically and just needs it written and documented, and then you have all the notaries there that just take care of it?
Yes, and we do execute documents. We're all notary publics. I'm a notary public, so. And interesting, you speak about, specific items. going to specific people. A lot of times what we do in a will is we include some language. We call it the leave a list language. And so you make a reference in your will to a specific list that you've prepared with specific items of your personal property that you want to go to specific people. Now, that leave a list language doesn't necessarily totally bind the executor to following that list, but if that's somebody that you trust and you know that you trust them to carry those out, that's one of the best ways to do it if you've got a lot of specific items, because nobody wants to lay out 2 pages in a will saying, I want the chair in the dining room to go to so-and-so and the table to go to so-and-so. And that language also allows you to change it. If you want to change that list over time, you're just saying that I do have a list and I would like that list to be followed.
We're stunned. There's a lot to think about. Yes.
There is.
Yeah.
Open the door and say, come and get it free.
I've done that deed for my kids. I mean, I've done that. I've got mine set up that way just for.
It's a great convenience, and the fact that we're able to do that here in this state is a good thing. And there is some language we include when we do these wills that say, or not wills, these deeds that say this deed also acts as a bill of sale for all of the personal property inside or on the premises. So what that means is it all transfers. Everything that's in there transfers with the deed. But it's subject to the same terms. So if you want to sell the dining set, you're allowed to do that. But just anything that's in there when you passes.
Except for the car in the garage.
Except for the car, which is controlled by DMV. And DMV does have a transfer on death form as well through their own services. And I think it's about a $90 fee to get it set up so that title to your car will pass the same way.
Quick question on back to enhanced life estate.
Yep.
To avoid
Medicaid. Yep.
Rather, sorry.
Nope. Common.
Does that have to be set up 5 years before they meet?
Yeah, so this is something that I should have mentioned. So a lot of people have heard about the 5-year look-back period. What that is when you're applying for Medicaid, Medicaid looks back to any transfers you've made in the last 5 years, and those can count against you, essentially. So if you're gifting to, say, your children 2 years before you are applying for Medicaid, Medicaid's going to look at that and say, well, that transfer is not really legitimate, and either the kids are going to need to transfer that back to you, and it's sold, or they need to buy it, or something. But this enhanced life estate deed actually doesn't factor into that at all. Because when you're setting up this enhanced life estate deed, you're not actually transferring it at the time you sign the deed. The transfer only happens when you die. So it's not in the look-back period. It's kind of this gray area. That's how you're able to avoid Medicaid on this, is because the transfer happens when you pass.
Yes.
Anything else? Anything need clarification?
Oh.
I know I dumped a lot.
I have one other thing. I had instance come up that my brother-in-law took his own life. And right before he did, he left a note to me and my son. And they called that a Holocaust will, and the probate court did not recognize that. So even though he wrote everything out, it was, no one witnessed it at all.
Correct. And the term that I think you're looking for is holographic.
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 Oh yeah, that makes sense.
This is when you hand write a will.
Yeah.
So in Vermont, a holographic will is not valid, especially if it's not been witnessed.
Right.
Now, if you've got some folks that are willing to witness your signature on it, that's a different ball game.
So if you handwrite your own will, does it have to be just witnessed or notarized? I mean,
Witnessed.
Witnessed is
Yes,
alright.
because notarization actually isn't a part of the will statute here in Vermont. There is something that's called a self-proving affidavit, but this is a separate document to your will, and that's a document that is notarized, that both witnesses and the testator, that's the person who makes the will, sign that affidavit. What that affidavit does is it makes proving a will in court a lot easier. You're able to file that affidavit, and if anybody wants to challenge the will, it's then upon them to bring up a good reason why it wasn't validly executed. So, but notarization isn't technically required on the will. A lot of states do require notarization or have shifted from witnesses to notarization.
So the self-proven just needs to be witnessed and signed?
It needs to be signed by the testator, both witnesses, and it states all the requirements of a will signing. So it's an affirmation that the person is more than 18 years old. It's an affirmation that they're doing this of their own free will. It's an affirmation that they asked the witnesses to sign. And it's an affirmation that they declared it as their will. So essentially it's a document that repeats all those requirements. Has to be signed by the testator, both witnesses, and a notary. And notarized. So when we execute a document at the office, we've got 2 people to witness, and then we've got 1 that's the notary. So we do an affidavit every time.
So the self-proven needs to be notarized as well?
Yes, the self-proving has to be notarized if you're doing an affidavit. Now you can do a will without one of those. You can just do it with 2 witnesses. That's fine. It's just an additional aspect of this to complicate things further.
Mark even wrote in his will that he knew that he wasn't doing it correctly and to hurry up and go up there before the state gets everything. He even wrote that in his will.
Oh, boy,
Yeah.
hurry.
That's why we store up treasures.
Do you have a couple of business cards that I could have
I
to
do.
give to
Oh,
some
good.
of my
Yes.
clients?
Oh, yeah.
Yes,
Great,
please.
thank you.
And I think they did include them, just so you know, in those bags as well. But if you
Oh,
folks
yeah, I
want
would
to
definitely,
take
take
some
some of my
more,
clients.
feel free to pass those around.
Yeah, that was my best lesson.
Well, I just want to say, people can also go to the Vermont Judicial website.
VermontJudiciary.org.
Yeah, yes, I don't need an extra. And they got a lot of information on there about forms and fees and this and that.
They do provide a lot of forms online.
I mean, it's kind of scary, but
Yeah, yeah, it will make you wanna just call him.
Yes,
Really.
yes.
Pay the $165 an hour.
Totally worth it.
So now we understand why it's so high. We used to wonder about.
Is it more difficult to leave your assets to a charitable organization? I don't have any children, and my nephew's a pothead, and they're not gonna get a thing. So,
I wouldn't say that it's more difficult. There are some little things like that transfer tax that we talked
Yeah.
about that you'd have to factor in. But if you didn't have the funds to pay that right now, and if the church didn't necessarily want to pay that right now, you can just leave a will that leaves it all to the church. Again, the only issue is that the church is then going to need to make sure that it goes through the estate administration process.
yeah.
It's good to put something in there saying that if anyone contests it, they're out because your pothead relative might try, just
Yeah.
because they're a relative.
Yeah,
I know.
Jeez.
Like, wow.
it's like, oh,
But I found that spending a little time with a fellow like this that knows what's going on, you can often come up with some ideas that you
Yeah.
hadn't come up with before, that can save you a lot of time, money, and headache.
Yes, and the big part about this is you're trying to save that on the back the back end of this. Is you're hoping that by spending that effort and that time and any money now that you're saving a lot of it.
I don't wanna leave a big mess, you know, that's
Right.
the whole thing, I want it
Yes.
cut and dried and.
And you wanna live, you don't wanna be busy worrying about if everything's taken care of. If you get everything taken care of, the quality of your life is so much easier, then you're not worrying about all that stuff, and you can just concentrate on having fun living, or dying easily.
Right.
Yeah.
Right?
Oh my, thank you so much, my goodness.
Well, thanks.
You're welcome.
Yeah.
It's good to
We
know.
need several of these, so.
Yes.
Like it's in and then it gets really in it and like it's in again.
Yeah.
Because right now I'm just like, okay, I heard all this, it's all.
This was recorded, right?
Yes, there's a
Yeah.
camera going. So.
Good.
Yeah, we might have to do this again.
Yeah.
Thank you for your expertise, right?
Yes,
Yeah.
thank you. My goodness.
Yeah.
More than welcome.